we have to get that clear. The panel of 5 that is hearing this Adom matter, this is the Vodafone's appeal to the Supreme Court from the Court of Appeal. Vodafone have now found evidence that they have a case, that they didn't have to pay $4 million, that they should have won the High Court case in Swedru if only the executive instrument had been found in good time by Lands Commission. Nonetheless, it has been found now. Okay, so they are going to the Supreme Court with an application to ask the Supreme Court that we want to re-argue our matter because we have found fresh evidence, and the legal procedure allows for that. The civil procedure rules allow for that. That they can go to Supreme Court and say, we now have fresh evidence. Can we re-argue the matter that we argued already in the High Court? Can the Supreme Court allow us to do so? Now, this panel, the panel of 5 right now, is led by Justice Dotse, and it excludes Justice Eni-Yeboah. Okay. So there's a bit of legal novelty in the whole application to the Supreme Court. Aspects of it is a legal novelty. We don't want to bore you with that because it's typically for lawyers. But all you need to know is that at the Supreme Court stage, there are aspects of this application that throw up a legal novelty. Now, Justice Dotse is telling himself that because the Supreme Court is the highest court of the land, whenever it gives a ruling on application and procedure, that ruling ought to be obeyed by all the courts down. Court of Appeal, High Court, Circuit Court, all of them must obey the Supreme Court's interpretation of a procedural matter. This Adom versus Vodafone case, now before the Supreme Court, with new evidence found, evidence which was not available at the High Court stage, evidence which was not available at the Court of Appeal stage, and evidence that if had been available, certainly the outcome would have been different. It would have been the opposite outcome. Justice Dotse is thinking that we are being invited now as a Supreme Court to deal with the matter of procedural novelty. He believes that in the circumstances, he has to write to the learned Chief Justice, who is his boss in the area, and say that, my lord, the panel of 5 is being invited to look at a legal novelty which will affect procedure as far as civil procedure rules are concerned. I am asking you, my lord, that can we enhance the panel so that we have an enhanced panel of the Supreme Court to look at this matter, so the ruling that comes out of the Supreme Court, because it's going to be binding on all other courts in terms of the procedure, that ruling is substantial, that it is heard by as many as 7 Supreme Court judges. Let's see the letter that Justice Dotse wrote to Justice Eni-Yeboah, telling the Chief Justice that our panel of 5 may be insufficient to deal with this substantial matter because it's a matter that will impinge on the ruling of the courts and all what the other courts will do. Let's see that letter. Now, this is the letter that Justice Jones Dotse wrote to the Chief Justice, and he copied all the other judges in the case. It is a letter that is written on 24th January 2020. It is written to His Lordship, the Chief Justice. It is written from the hand of Justice Victor J.M. Dotse. It is copied to Justice Apao, Justice Puaman, Justice Mafosao, and Justice Professor Ni Ashikote, Justices of the Supreme Court. The subject of this letter is a request for enhanced panel of the Supreme Court to consider ruling in suit number JS 1312019 instituted Adom-Otchere Kwesiata versus Ghana Telecom Limited and Lands Commission. Let's get the details of the letter in a way that you can see it. So this is how it starts. Justice Dotse writes to the Lord Chief Justice. This is to respectfully inform you that I am the presiding judge in the suits listed above, suits number so and so, instituted Adom-Otchere Kwesiata versus Ghana Telecom and Lands Commission. I also wish to further inform you that the panel had adjourned the suit for ruling to Wednesday, 22nd of January 2020. However, due to the Christmas holidays, the panel was unable to hold judgment conference on time. As a result, we have had the ruling adjourned to Wednesday, 5th of February 2020. However, during our deliberations at our judgment conference on Thursday, 23rd January 2020, it emerged that the main issue that calls for our determination is that of the proper scope of executable and non-executable judgment and how these affect the principles for the grant of stay of execution. Now, I told you before that the matter before the Supreme Court was calling for a very detailed ruling on the procedure rules, and I didn't want to bore you with that. So don't worry, that's what the lawyers call it: executable and non-executable judgment, and how these can affect the principles for the grant of stay of execution. So this fundamental procedural matter was going to be ruled upon once Vodafone have filed an application before the Supreme Court asking for the court to allow them to show the new evidence. This executable, non-executable, whatever they call it. That's the procedural matter. Upon which Justice Dotse is telling the Chief Justice that the ruling will now require this decision to be made. It will be a far-reaching decision because the consequences will be far-reaching, I should say, because it will impinge on how all the other courts manage this executable and non-executable judgments and how they affect the principles of stay of execution. Okay, let's move on. Anticipating that the resolution of this issue in the ruling might necessitate a departure from the settled authorities of the court, we respectfully crave your indulgence to enhance the panel to 7 to enable us re-hear the matter to be in a better position to deal with the issue comprehensively. Very, very interesting. I really like Justice Dotse for this particular intervention he made. He's telling the Lord Chief Justice that a resolution of this matter might occasion a departure from what is already known in the courts. That's what he means by settled authorities. So that there's a procedure that all the courts adopt when it comes to the grant of stay of execution in executable and non-executable. Forget about that for now. There's something, there's something that the lawyers always do when it comes to procedure. Justice Dotse is suggesting that considering this Vodafone matter and what they are being invited to do, the thing that the lawyers always do may have to change. There may have to be a departure from that for new learning, something new, something more progressive. He's suspecting that in looking at this Vodafone and Adom matter, given this new evidence matter, there may be some fundamental changes to the procedure of what they had already known. So he's asking the Chief Justice to enhance the panel so that they will be able to deal with the matter comprehensively. Okay, let's see the last sentence. Respectfully submitted, Justice Jones Dotse. So this is the letter that the Chief Justice received. The learned Chief Justice then agrees with Justice Dotse, and so he brings in 2 more people into the matter. So from 5, now there are 7. That is himself and another judge. The Lord Chief Justice brings in himself and another judge. So there are 7. The 7 judges then make this ruling. Listen to what happened. So the judges are now 7. We know that already. The 7 judges then make this. And let's read it. It says, on the 28th of April 2020, the Chief Justice presided over an enhanced panel who went ahead to grant an order for stay of execution of Adom-Otchere's judgment. In other words, the Chief Justice led the court to order that the execution of Adom-Otchere's judgment be suspended until the determination of the appeal by the Supreme Court. Now, this is very serious because here, the Chief Justice, the man who they say is in cahoots with Adom and has promised Adom something and Adom wants to bribe him, he's leading a panel to actually say to Adom that we are going to stay the execution of the judgment that you have. We will not allow you to enjoy the benefits of the judgment that you have. We will not allow that judgment to be executed because of the new evidence that Vodafone has found. This is the Chief Justice leading that charge. Now, the CJ doesn't just end there by leading the panel to grant the stay of execution so that Adom cannot enjoy the benefits of what he is supposed to get. He does something else. Have a look. Let's look at 13. It says, the Chief Justice also led the panel to make an additional order, consequential order, which was not even specifically asked for by Vodafone and its lawyers, that Adom should refund into court the part payment of the judgment debt of some $4 million United States dollars that had already been paid Vodafone. Adom was ordered to pay $4 million into courts. That's very serious. So this is the Chief Justice who comes into the matter, invited by Justice Dotse to enhance the panel because of what they needed to do. We talked about that already. He comes and he leads the panel in a unanimous decision to say that no, Adom, that judgment that you won in the Swedru High Court, the execution of that judgment, we will stay it because there's new evidence coming that shows that maybe you shouldn't have won that judgment. This is the Chief Justice. He doesn't stop there. He goes on to say that 4 million that the Court of Appeal gave you, the one the Court of Appeal said, you have won a judgment of 16 million. The opponents are appealing. We will give them a partial stay. However, they should pay you 4 million United States dollars, being 20% of what is entitled to you from the judgment. Chief Justice says, no, even that money that you receive, return it. Return the money in 1 month. This is the Chief Justice who is said to be on the side of Adom in this matter, leading a panel to do something that even Vodafone didn't ask for. Vodafone didn't ask for it. They just went and said that, can you stay the execution? They've already paid the 4 million. They are waiting for when the matter ends and they win. They said, can you stay? Chief Justice says, we will not just stay. Adom, pay back the money. Now, here is the evidence of the money being paid. This is a document from the court. And it's Adom Obrenu versus Ghana Telecom, the parties, etc., etc. This is the court order. We put the court order in a bigger size so that you can see it. Here is the court order. And it's signed by Justice Enieboa, the presiding judge. It says, the unanimous decision of the court is that the application is granted, as the application for stay is granted as prayed. Any money that has been paid under the order, which is the subject of this repeat application, must be paid into court within 1 month from today. Adom is looking at this matter. He's hot. He's very concerned. Then the matter starts coming out. Adom is now going to begin a quarrel with his lawyer.